Yeah, this is it. This is the drive. The link to the readings?
Yes. Eventually yes, this is it. Click on the first. No. That is, okay, no, that's going to become later. It's before that. No, all those links come later.
Okay, well, these are the only links that he said, so.
No, you should have said, because I got it myself. No, that's still the same one. It's the same one, it's from the same book. Okay. Now that looks good. So,
And is like begin?
yes.
Okay, so you just want this on the screen?
Yes.
Okay, that I'm not sure how to do.
Okay. You know how do we get the thing on the screen?
I'm not sure.
You know what,
Can you
let's turn this
projector?
on. You know what, let's just turn this on. I've worked with these before, let me see. It's a hard drive around here somewhere. Let's give me a contact.
You'll get everything going in a minute.
Hi. Happy birthday. Thank you.
How do we get that image on the screen?
It was last week.
That I'm not sure. I think the screen was already.
Yeah, but I
No, I'm
know.
riding my bike.
It was.
How about right there? It's already on, but it's not projected.
Yeah.
Maybe this is the research.
You did? I'd be interested to try it, because I don't know where to get it.
Okay, let's wait 2 minutes. Give me 2 minutes to get.
Yeah, you may want to get someone's.
You know how you get an image here on the screen?
What happened to everyone? They just wanted to be here for the first couple of
Maybe just because it's such a nice day.
Supreme Court decisions. Do we know anything?
We?
I mean, is there any information that anyone does? It didn't beat the elements, did it? Or something? Yeah, I heard that was it.
Oh, you didn't know? Yes.
Don't see it once. Don't look at there.
Yeah. Let's try source search. Okay.
Did you get anywhere with this?
Here. There we go.
Yeah.
Now you can just roll. Yeah, there we go. Now it's, we got
Oh,
it.
we got it.
Yeah.
We got it.
We got it.
Okay, I was calling the NYPD. Okay, so let's plunge into it. For the future, just tell me what did you do, so in case
We turned the power on.
you get hit by a truck, I will
We
know.
hit whiteboard.
Okay.
Well, we hit the power first. I think that was
You're right.
funny.
Now that's good. Okay. So let's just give it 2 seconds so I don't make a mess. It's a library.
We should respect them.
I saw this before. I know the same.
Is that familiar?
Okay. So first of all, let's see what I have here in the way of extras. I should have something. Okay. So this, if you weren't here, because we'll be looking at the handout, I think you didn't get one. You didn't get one. You didn't get one. Okay. Okay, so the only thing I have to do now is put on my reading glasses. If I can see anything as these ones. Almost positive. I brought them. No. Okay. All right.
Norma?
Yes.
What's up here on here, or is this a completely separate reading?
Separate. But we're going to project that too, because that was the 5.
Okay.
Okay. So,
Yeah.
no, we have started. Don't encourage him. We are in the middle of class. You are very far behind. And it will take a Herculean mental effort, exertion, for you to catch up with us.
We'll be waiting still longer than 19.
Okay, so to recapitulate for the newcomers, as well as the delinquents and truants, we completed the 2 classic cases on segregation, Plessy versus Ferguson, and Brown versus Board of Ed. We're now plunging in Roe v. Wade, and we'll finish Roe v. Wade today. And then next week, I haven't yet sent it because I'm working very hard at it. It's a complex issue. This week we're doing when does life begin, Roe v. Wade. And next week we will begin the 2 classic sodomy cases, the Hardwick versus Bowers and Lawrence versus Texas. They were actually decided only within 17 years of each other. One was 1986, criminalizing sodomy, and one was 2003, decriminalizing sodomy. And it's one of the very few cases where the second decision outright says the first decision was wrong. It just straight out says the first decision was wrong. As we will, I will try to convince you next week, I think the first decision was probably right, decriminalizing sodomy. I haven't yet been able to carefully look at the second decision, but I think the arguments criminalizing it are much stronger, just as I will try to show today that the arguments in Roe v. Wade, the side that won, the majority opinion, I think was quite weak, as we began to look at last week. Okay, for the sake of those who came in either weren't here last week or just started this week, and in fact there are several who just started this week, 1, 2, 3. Can somebody recapitulate for the whole class, basically, what were the arguments we reviewed last week? Does anyone remember, or has now last week receded into the hoary past? Hoary is H-O-A-R-Y. It does not refer to the status that some people ascribe to Stormy Daniels. It means a time in the long, long distant past. where it's covered now in dust and soot. So, can anyone recall for us, where did we leave off in the last class? Let's look at paragraph A. What was the general argument made in paragraph A? Does anyone recall? This is when I begin to despair of my pedagogical skills, where everything vanishes in a week's time. Yes?
Hippocrates' view against abortion, the ancient Greeks, that's the ancient Greeks.
And what was the argument we basically discussed last week? Thank you.
The fact that the court, in trying to be objective, just referred to Western Greek Greco-Roman tradition and did not go to a wider place through multicultural, African, Asian, whatever.
Yes, the two issues we discussed last week were, number one, when the court wants to look at the antecedents, the moral, the medical, the historical, the philosophical antecedents to Roe v. Wade, it looks at basically two bodies of philosophical reflection and legal reflection. And the two bodies it looks at are first the Greco-Roman era, and then it looks at the English and early U.S. common law era, what they have to say about abortion. And the main argument I tried to suggest last week was, first of all, why Greco-Roman? Why not Indian, Chinese? Why not, somebody suggested there were great non-Western doctors, not just Hippocrates, but there was some suggestion about Avicenna. Who else was named? Maimonides. And the question became, is it legitimate in trying to formulate an answer to the question of where does life begin? Is abortion a legitimate medical procedure? Is it proper, is it correct to limit the range of antecedents, the range of precedents, to simply the Greco-Roman and then British law and American common law, which was mostly appropriated from Britain? That was the first question we asked. The second question we asked was, what difference does it make? Most of these references are to an era where there was virtually no scientific medical knowledge of the fetus, of the reproductive process, and therefore, who even cares what some law happened to state in 1850? Forget about Greco-Roman, I'll even go all the way up to the near present. Who even cares what some law in 1850 had to say about abortion? Clearly, as I think, remind me of your name?
Arnie.
Clearly, as Arnie pointed out, it was a kind of not legal, but it was a strategic move, because the court was trying to prove what? Who remembers? What was the court trying to prove? Yes?
Precedent.
But what precedent were they trying to prove?
When is life viable?
But what was the precedent that they were trying to demonstrate?
That it was built into the
tradition.
Oh, I'm sorry.
Not exactly. It was a political move by the court. It was trying to show that until fairly recently, abortion wasn't illegal. that this notion of this illegality of abortion they tried to show was either in the far past, the legacy is ambiguous. In some eras it was legal, in other eras it was illegal. It happens that Hippocrates was clearly against the abortion, but then the court tries to water down the opinion of Maimonides, the opinion of Hippocrates, but no point in going into that now. But then the court says, until the last third of the 19th century, abortion was not illegal in the United States, or when it was illegal, it was relatively a minor affair. It was a misdemeanor. And it was clear, as Arnie suggested last week, that the reason for this history, and one of the people who's not here today, she made the point after class, I was surprised at how shoddy the history was. You didn't have a sense that these people had really mastered a body of historical or medical knowledge. What clearly was happening is what they were picking and choosing, trying to find things which would soften the blow of legalizing abortion. They want to show when we're legalizing it, we're not really doing something so radical or revolutionary. And if you look at the long sweep of so-called Western civilization, whether in the distant past or even in our own country's recent past, it's not really so shocking what we're attempting to do. And the reason for that, as Arnie suggested, was it had nothing really much to do with the science or the history or the philosophy. It had everything to do with, as we discussed last week, the court is constantly accused of usurping power. Because in a democracy, who is supposed to make the decisions? The people, the legislature. And the court is constantly being accused of 9 men, and back then it was 9 men deciding the law for the whole country. And it's being said that's clearly undemocratic. They're usurpers. The court, of course, claims we're not really deciding the law. We're looking deep inside the Constitution for what the law is. Because the Constitution is the foundational legal document of our society. So they say we're not legislating, we're not usurping authority, we're just doing what judges are supposed to do. We're looking at the law and seeing what the law is. Now, as everybody in this room knows, on all the issues that we're discussing, there is no clear, unequivocal guidance granted by the Constitution. There is no amendment or article that says abortion is legal. There's none that says abortion isn't legal. So then at some point, you have to read into the Constitution. And that's where things become very tricky. Namely, what, pray tell, are you reading into it? And are you really reading into the Constitution? Or, yeah, this was the woman. I was commenting on what you said last week about how weak you found the history part of Roe v. Wade. Very underwhelming. Yeah. So the question is, are they reading into the Constitution, or are they reading their politics into the Constitution? Seeing in the Constitution what their political predisposition wants them to see in the Constitution. Okay, so let's now continue. Let's look at, did we leave off at C or D? Does anyone see? Okay. Now, they're looking at the period towards the end of the 19th century when, according to this history, and I have to say, you have to always be cautious about whether the history as it's rendered in these decisions is history or is it what's called a atid history. Namely, you collect all the data to support your point of view.
Actually, we might not have done D, but some of the medical.
Excuse me?
I'm not sure if we did do D last time.
No, we didn't do D. We didn't do D.
Yeah.
Okay, so D, who would like to read it? Good. Schiffer?
These reasons have been advanced to explain historically the enactment of criminal abortion laws in the 19th century and to justify their continued existence. It has been...
Just let me stop for a moment. So now they're looking at that period beginning in the late 19th century when abortion is criminalized. Go ahead.
It has been argued occasionally that these laws were the product of a Victorian social concern to discourage illicit sexual conduct.
Okay, so one theory is they enacted these laws in order to discourage extramarital sex by punishing those who had extramarital sexual relations. Next.
A second reason is concerned with abortion as a medical procedure. When most criminal abortion laws were first enacted, the procedure was a hazardous one for the woman. This was particularly true prior to the development of antiseptic techniques, of course, were based on discovery by Lister Pasteur and others first announced in 1867, but were generally accepted and employed until about the turn of the century.
But were not generally accepted and employed.
But we're not, right, okay. Abortion mortality was high, even after 1900, perhaps until as late as the development of antibiotics in 1940 standard. Modern techniques such as dilation and curative were not nearly so safe as they are today. Thus, it has been argued that the state's real concern in enacting a criminal abortion law was to protect the pregnant woman, that is, to restrain her from submitting to a procedure that placed her life in serious jeopardy.
Okay, so they're now reviewing, recapitulating the various theories why abortion became illegal. As you can see, the first two theories, it's going to be very easy for the court to strike down. It will say regarding the first theory that we have passed the era of Victorian morality, and therefore that can't justify any longer criminalizing abortion. They will say regarding the second explanation, but what will they say? I shouldn't be supplying the answers, that's poor pedagogy. What will they say regarding the second justification for criminalizing abortion? Yes?
Because of modern medical techniques, it's no longer quite as dangerous.
Exactly. They will argue, in particular in the first trimester, in fact, there are more deaths from birth than from abortion. So, as you can see, they are again, so to speak, setting up the argument in order to justify the decriminalization of abortion, saying that the justifications that were put in place in the late 19th century no longer apply. Let's look at the third one. Okay, they're going to explain the second one right now. Go ahead.
Okay. Modern medical techniques have altered this situation.
Referring to the second paragraph. Go ahead.
Appellants on various amnesty refer to medical data indicating that abortion in early pregnancy, that is, prior to the end of the first trimester, although not without its risk, is now relatively safe. Mortality rates for women undergoing early abortions where the procedure is legal appear to be as low or lower than the rates for normal childbirth. Consequently, any interest of the state in protecting the woman from an inherently hazardous procedure, except when it would be equally dangerous for her to forgo it, has largely disappeared. Of course, important state interests in the areas of health and medical standards do remain.
Right. And that's going to set them up for saying, after the end of the first trimester, issues of health do become pertinent, and therefore the state has the right to intervene, beginning at the second trimester. Go ahead.
The state has a legitimate interest in seeing to it that abortion, like any other medical procedure, is performed under circumstances that ensure maximum safety for the patient. This interest obviously extends at least to the performing physician and his staff, to the facilities involved, to the availability of aftercare, and to adequate provision for any complication or emergency that might arise. The prevalence of heart mortality rates at illegal abortion mills strengthens rather than weakens the state's interest in regulating the conditions under which abortions are performed. Moreover, the risk to the woman increases as her pregnancy continues. Thus, the state retains a definite interest in protecting the woman's own health and safety when an abortion is proposed at a late stage of pregnancy.
Okay, very good. And now let's look at the question I pose. I would like to hear your responses. Does the state have the right to restrict abortion on the grounds that it might endanger the woman's health? Or is this strictly a personal decision by the woman? Can the state say, if the likelihood of medical dangers dramatically increases beginning at the second trimester, does the state have the right at that point to start regulating, among other things, the competence of the physician, at this point it was men, and his staff, the facilities involved, the availability of aftercare, adequate provision for any complication or emergency that might arise? Or does the woman have the right to say, it's my body, the organism inside me is not a living organism, and I have as much right to decide how to proceed as I would if I have a toothache or an infection. The state has no right to tell me that, well, in the case of toothaches and infections, if you go to the doctor, of course the state regulates the medical profession. Does the state have the right to intervene if it's, a woman's health is at risk? Or does the woman have the last word? If she wants to go to a doctor who may not be up to snuff, that's her right because it's her body. But we can't go to a dentist who's not up to snuff. But we can. We can.
Hey, Jesse, can you move the screen up?
She just asked to lift
Can
it
you
up a
just show the
little.
question?
Yeah.
Sure, sorry.
Thanks.
Okay. Comment.
Yeah, I think the state has the right to control the conditions of hospitals and so to make sure that people, that doctors and so forth are operating on a safe level. I think the state only has the right to legislate whether a woman can have an abortion or not and where she has it if it considers the woman less than a citizen.
Less what?
Than a citizen. Less than a full human being.
Yes?
the state has the right to intervene on behalf of anyone's health in the case of suicide. Because if you threaten, I'm going to kill myself, the state absolutely has legal grounds to come in and take you and restrict you from doing it.
Is that right?
No, that's true.
It's not a matter of right and wrong, it's about the whole process. I mean, we can argue right and wrong all the time.
We don't have the
It's easy
legal
to-
right to commit suicide, no.
But if you
We
just
are
accept the law.
compelled by law to endure 3 more years of Trump. Suicide seems so much more humane. Yes, go ahead.
Oh, me?
Yeah.
No, I was thinking that the state has a right to legislate the facilities and the quality of the medical personnel who are deciding whether or not this abortion is safe for the woman, the facilities where she gets it, is the proper care provided. But in any other surgery, it's the medical people who decide whether it's safe or not. If a doctor says, I can't perform this because it's not safe for you, you're not a candidate for the surgery, or it could be the same for an abortion.
I don't think they would object to that interpretation.
I think that the state does not have a right to say to a woman, you cannot have an abortion in the second or third trimester because it's dangerous, but they can just regulate the facilities in which women have abortion in the name of their safety. Like,
Let's put a hold
I
on
can't
that,
have
because at the
plastic
end they're going to describe what the state is allowed to do on the aspect of the medical safety. Yes?
Well, if you go to anybody, like your neighbor, and you say, well, she or he says, I can give you an abortion, and if you say, it'll be fine, and I will charge you whatever. And then the woman dies, because the person didn't wash their hands. Then I mean, you can see how that person has committed a crime, not only a murder, but a fraudulently.
So at this point, if I can...
It seems to me that the state does have an interest in seeing that people aren't killed and made.
Right, okay, so at this point, you would say the claims of the state are legitimate.
Yeah, I would.
Yeah. I'm inclined to think so also, but I want to further see exactly how far that claim extends, and I've forgotten. Yes?
So, but does that mean that the woman has to only have an abortion in an approved facility?
I think yes.
See, then if there is no access, if that doesn't come up with access, and let's say she happens to go to where she can get to, or, you know, and a hospital but not one of those regulated by the state, then does that mean she's going to be imprisoned or, you know, criminally charged for that?
Let's see. I want to put a hold on that. We'll put a hold on it. Let's go on. So far, the 2 claims they make are abortions were criminalized because of Victorian morality. Abortions were criminalized because of medical dangers. Now they're going to look at the 3rd reason. Go ahead. Let's have someone else read it. Who would like? Good. I'll let Arnie, because we don't want to discriminate against men. That's gone on too long.
The 3rd reason is the state's interest. Some phrase it in terms of duty in protecting
If you're having trouble seeing, yeah, just give me some
prenatal
here.
life, some of the in protecting prenatal life, some of the argument for this justification rests on the theory that a new human life is present from the moment of conception. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. Only when the life of the pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. Logically, of course, a legitimate state interest in this area need not stand or fall on acceptance of the belief that life begins at conception or at some other point prior to live birth. In assessing the state's interest, recognition may be given to the less rigid claim that as long as at least potential life is involved, the state may assert interests beyond the protection of the pregnant woman.
Okay, alone. Now, here is where the court is going to make its move. And it's going to make that fundamental determination on who's right, pro-choice or pro-life. And so I want to look carefully at the wording. At this point up to here, we are setting up the pro-life argument. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. That's the pro-life argument. Now, they say, only when the life of the pregnant woman, pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. The standard argument, which seems to have been incorporated in virtually all, not all, no, actually I would say probably all, virtually all legislation that criminalizes abortion, virtually all of it makes exception in one case. What's the exception? When the mother's life is at stake.
Or her health is seriously.
Or her health is seriously impaired. The other typical exceptions is everyone. The typical exception is rape. In the case of rape, it's also said in the case of incest, but in most cases the incest was the result of a forcible force being exerted. Okay. First of all, as a logical point, speaking to those of you who are mothers in the room, I don't even think this is correct. Only when the life of the pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. I think most mothers would say, between me and the child, assuming it's a child, who should live? Who?
The mother. The child.
No, not the mother. Most mothers who sacrifice their life for their child. That's why if a mother sees a child, their child in the street, and the car is coming, what does the mother instinctively do? What?
Throws yourself in front of the child.
That's correct. So, I think if you're consistent on the pro-life position, it's not even correct that an exception is made if the life of the mother is at stake, because it's your child. And most mothers will put their child's life, if you believe it is a life, ahead of the child. There's no logical reason. The opinion of a mother usually is to put the life at stake, and logically, who should live? The one who's never had a chance to live, or the one who's already lived a good portion of his or her life? Okay, let's hear the objections. We'll start with Shifra.
I totally disagree, because the embryo is not a guaranteed life yet. You don't know what's going to happen in the second trimester. She could lose her child. The mother's life, you could see she's in front of you. I mean, yeah, something could always happen to the mother too, but it's a life that we can see, we know for sure is a human life. Whereas at the embryo, anything could happen.
Shifra, when the car is coming, and as, remind me of your name?
Marjorie.
And the mother thrusts her body between the child and the car, the likelihood of the child living is also very small. But the mother will do it anyway.
But that's already a child. However, if you're talking so about the embryo, there's a difference.
Well, that's voluntary.
Carrington?
If
women were willing to give up the child for their
Well,
life?
the answer to that is pretty straightforward, though we're going to look at it later, arguments again. The answer to that is very straightforward, because 99.9% of the women who have abortions are convinced that thing in their body is not a child.
You know that statistic to be true?
I have in my life only met one woman who point blank said to me, yes, I know that's a baby, and I'm killing it. That's a very, very difficult admission to make.
I think that some of the millions of women that get abortions would make that admission. Or I wouldn't call it an admission, would have that taken out of him.
Well, look, I completely defer, I always do, to expertise, and I'm sure you know many more people than I do. My impression is the bedrock position of pro-choice people is that the fetus is not a child.
It's not a human life.
No, it's not.
Yes. Go ahead. I'll go around. I'm not, you're correct. You should say to me the basis of that statistic, and I say freely, that's been my experience. Go ahead.
Yeah, I think that not only one's own child is the chorus coming, who one wants to save, but any child that you see.
Yes.
Now, but with the abortion, saying that the mother would feel that the child comes first, there's a difference. Basically, yes, it's my child, but it's not really my child yet. It isn't something that's formed that you have an attachment to, except that you know that it's growing in. So I think the difference between saving any child that you see in danger and making the choice between having keeping the child if it's viable or not. The mother might.
But Barbara, isn't there an element of hypocrisy to that? If you truly believe that organism in you is a baby, if you truly believe that, then I can't see why you would put your health and even survival against that child. I don't see that. I think there's an element of hypocrisy there.
You might even, and this hadn't occurred to me before, be concerned about what's going to happen to that child if I'm gone. If who's going to care for it, what will be it may not benefit the child. But aside from that, my basic feeling is that that thing of self-preservation. That I don't know because I've not had the experience of it.
But that's why I say it's an element of hypocrisy. It's your will your desire to live. It's not because what?
Yeah, well, what a parent does for a live child is voluntary. There's no law saying the parent must protect the child at the expense of its own life. And abortions also, well, I choose to have this abortion. And that's what the person chooses, and it may be based on the fact that the fetus is not a human life, or whatever it's based on. This is what the parent, the mother, does not choose to sacrifice her life, because parents voluntarily protect living children. It's not a legislative thing that parents protect living children.
That's correct, and we're going to go back to that. We're going to return to that. Allow me, let's just continue. Now they say, and this part here I find, if I may preface where we're heading, I find this wholly disingenuous, which is the fancy word for dishonest. It says, logically, of course. Now, let me tell you something about language. Whenever an argument is being made, and you see of course, the of course, or clearly, or obviously, that's always inserted because it's not of course, not clearly, and not obviously. So, logically, whenever somebody says that's ridiculous, you know it's not ridiculous. Logically, of course, a legitimate state interest in this area, meaning the life of the fetus, need not stand or fall on acceptance of the belief that life begins at a conception or at some point, at some other point prior to live birth. Okay, read that sentence on your own.
It doesn't make the interest is irrelevant.
What it's, okay, one second, just read it to yourself, read it to yourself, and then we'll look at that sentence.
That's a prophecy.
Now, what problem do I have with that sentence? Arnie is reading intensely, trying to discern and deduce.
It's giving away kind of a stone in its own foundation of its own argument. It's saying that we don't have to decide whether life begins at conception or not.
It says we don't have to decide whether life begins at conception or not. The problem is, if life does begin at conception, then the state should be regulating it from the moment of conception. Logically, it's just the opposite of what they say. Logically, a legitimate state interest in this area stands if you accept that life begins at conception.
They need not stand.
Yeah, but it's just the
It's just
opposite.
the opposite sort of concept.
If life begins at conception, then logically the state does have an interest from the beginning. And they say, logically, the state interest does not have to stand or fall on when life begins. The opposite is correct. If you accept that life begins at conception, then logically the state does have an interest from, so to speak, the get-go. And not only does it have an interest, it has an obligation and a duty to what? To step in and
Stop.
what?
And protect the fetus.
Exactly.
But that's only inferred, very, very vaguely inferred. That's not explicitly said.
Oh, but
You're playing with language, and I see where you're going, but it's only inferred.
yeah, but that's going to be, that sentence is their critical move.
Yeah.
Because everything else is going to follow from that. They are claiming that it makes no difference when life begins regarding when the state has an interest. No, it makes all the difference in the world whether the state has an interest depending on where life begins. What they're saying there is it's clearly evading the critical question. And the critical question has to be, is that a baby? If it is, logically, the state's interest enters at the get-go. If I'm misstating something, tell me what. Because this is all supposition by me. I would just go around, I'm going to get to Arnie. Yes. Your name is Arlene?
Ellen.
Ellen.
If you think that life is really incremental or emergent
Yes.
phenomenon, then I think that what they're saying is true.
But what if you don't believe that?
Well, there are people who don't believe it.
Right. And if they are emphatic about that,
Right.
then if you believe that, isn't it correct that logically the state's interest begins at conception?
For them, but I don't hold with it.
I recognize you don't hold it, but
I
you
mean, I
have.
think there is an element of time.
I understand that you personally, but the state is.
Personally, I've
but-
lost,
But what they're saying
feel
is.
loss at various stages. I can tell you there's a big difference.
Yes, I'm not going to argue that. I'm right now trying to see whether their argument holds. They say logically there is a distinction between when the state has an interest and when life begins. Well, that's not true. Logically, the state has an interest from the moment life begins. What
Well,
does
it says that it has a state interest at any point. That's what it's saying. It's saying the state has an interest at any point. Because our interest doesn't have to fall or stand at any idea about what a human being is.
Yeah, but that's incorrect.
That's what they're saying.
If you believe that there's a child there from conception, then of course the state has an interest from the beginning. How can it not? It's a baby. Yes?
I think that I agree with you that that sentence is incorrect and deliberately so. But that the state has an interest if it believes that life begins at conception. But I think the fallacy is holding the life of the baby above that of the mother. If you believe the mother is just a vessel for the baby, which they did believe at that time, then, fine. But the mother is, according to the Constitution, an independent, non-slave.
Yeah, but I'm not going to go there yet. However, I would have to say your language is loaded because you said putting the life of the baby above the life of the mother. But that's not what's happening. It's putting the life of the baby above the burden the mother must bear for 9 months, which is different. It's not like we're saying the baby lives, the mother dies, or the mother lives, the baby dies. That's not what we're saying. That's not what abortion is about. So it's not putting one life above another. It's comparing burdens. Right, yes? You're right, Diana.
I kind of want to reorganize my thoughts.
Okay. Somebody who hasn't spoken, you were...
Well, I just said, I guess we're going into some of these other things, but it's like the hypocrisy of if they care about the fetus, but they don't particularly care when the child is born, or if the pregnant woman has adequate health care while she's pregnant, or if there's proviso, to actually, take care of this child.
But what she said is, I hear you, and of course there's an argument there. The argument about pro-life people, life begins at conception, it ends at birth. I recognize that. But wouldn't you acknowledge that that's a separate issue? I'm not saying an irrelevant issue. It's a separate issue.
It's hard to say it's a separate issue because if a woman has the baby, it might not allow her to, frankly, have a better life, a better family later on in life. I mean, many people make the choice, maybe when they're young or something, not to have the baby. And it totally makes a difference in their later life. And I don't think they can be separate. If you can't afford a child, if you can't take care of a child, and you know that, then it's very difficult.
I'm not going to dispute that, and as Shifra mentioned already in an email to me, and as we'll discuss later, there are now all sorts of technologies that make that argument much more difficult, whereby there are ways to raise a child even at conception outside the fetus. There are all sorts of possibilities like adoption, which make those kinds of arguments more problematic, and we'll get to
But
that.
this sounds like a breeder class you're talking about.
Well,
Yeah.
It's kind of like a handmaid's tale.
Yes.
It's invasive.
All right.
Get that fetus up.
Okay, we're going to get, that was the purpose of the handout, we're going to get to that. Now, let's see what the court now says, because these are the key sentences. In assessing the state's interest, I'm going to continue.
You know, okay, in assessing the state's interest, recognition may be given to a less rigid claim that as long as at least potential life is involved, the state may assert interests beyond the protection of the pregnant woman.
Okay. Now, what is the key move? Who can identify what is the key phrase in this sentence, which is a political claim?
Potential life.
No.
Beyond the protection of the pregnant woman?
No.
The less
The
rigid.
less rigid.
Less rigid. The court is now using language in order to justify its determination of when it's right to intervene. It's going to say, if you believe life begins at conception, you are being what?
Dogmatic.
You're being dogmatic. You're being rigid. But here's the question, and feel free to disagree with me, because I don't have the answers. I'm just analyzing it as the expression has it. We're parsing the text together. Has the court made any proof? Has the court offered any proof, adduced any proof that the view that life begins at a conception is rigid? What's the basis for calling it rigid?
Calling it
For,
belief.
for all we know, it does begin at conception. They certainly haven't demonstrated anything to date so far in the text, have they? So what grounds do they have for now proclaiming that if you don't agree with us, if you think that life begins at conception, you're being rigid, and we're being less rigid? What's the basis for that? I didn't see any evidence.
Scientific. It links up with the scientific progress that has been made in the management of abortion and making it safe. What they're trying to say, I think, is that we shouldn't pin our belief on only this life beginning at
But why
conception.
shouldn't we? Science hasn't proven, and as a matter of fact, science can't prove when the life begins.
Yeah, well, I
So
think
then why? So for all we know, those who say it begins at conception are not being rigid. They're being as biologically correct or incorrect as those who say it doesn't begin at conception. What is the basis? All the court's saying is, you're not flexible like us. But what's the basis for saying we're... Okay, good. Hands up. Go ahead.
And they're also saying you're not being as scientific as us.
Well,
you're not looking at the medical
and you know what?
progress.
And they could say right back, and you're not being as scientific as us. Pro-life can say that. There are doctors who know everything about the fetus and the embryo, and they say life begins at conception. Yes?
By using the term potential life to cover themselves, like saying, okay, the fetus may or may not be alive, it's probably not, and it will turn into a life if the pregnancy continues. So it's potential life, but it's non-committal. The phrase is not committal.
Well, what they're going to say, as everybody knows who knows Roe v. Wade, they said, we're going to use the standard. If the fetus can sustain itself outside a woman's womb, then we're going to count as potential life, and you lose the right to abortion. It may not be valid, but it certainly doesn't make it more or less valid than anybody else's. They've not provided any evidence, any proof, any argument. My point is very simple. They're coming up with a completely arbitrary standard of when you should have the right to an abortion and when you don't. But they want to pretend as if their standard is more just than competing standards. But they haven't presented any evidence to that. Their standard is as arbitrary as any other standard that's been presented. Schiffer, and Karen.
I think they make the best argument for the pro-abortion people, because the whole argument of pro-life is that life begins at conception. Mm-hmm. And with those couple of sentences, they're just eviscerating that.
Well, I have to totally disagree with all due respect, because I don't see, this is the thing I said, one of the purposes of the class is to see, are there arguments being made here, or is it politics disguised as law? So I'm looking, we're all looking at it together. These are the key sentences in Roe v. Wade. Everything else, everything turns on these sentences. I'm looking at it just as you're looking at it, Shifra, but we're looking at it obviously through two different lenses, because I don't see an argument. I see a fiat. We say it begins when life is viable outside the womb. Anyone else's opinion is rigid. That's not an argument.
Right, but they're acknowledging that life does not necessarily begin at conception.
Right, but then they go on to say a state has an interest when the fetus is viable outside the womb. I think the only possible justification for using that as the cutoff point is because, in your opinion, that's when life begins. Because if you believe life begins earlier, then the cutoff point has to be earlier. So I don't see an argument here. That's my problem with Roe v. Wade. Now you can make the argument, well, Norm, didn't you just say a few moments ago science can't prove it? Correct. Okay, I'll say yes. Then you can make the argument, then the court couldn't have made a determination because it's impossible to make. I would say fine. But then I would say, I don't think the courts then should be deciding it. And I think it should be decided in the legislative branch. Let people decide by majority rule when do you want abortion. But don't pretend here that you're making some sort of legal determination that's grounded in the Constitution. That's not what's going on here. You're just taking your politics and smuggling it in through this claim that somehow ours is the right standard. Your standard is as arbitrary as any other.
Now, all I'm saying is that really the acknowledgement that life doesn't necessarily begin at conception is...
I don't think that's an acknowledgement. I think that's a dismissal of the pro-life position.
Yeah.
Well, that's exactly what I'm saying. That's exactly what I'm saying. That they make a very good case for those who are pro-choice. Because if life does not necessarily begin at conception, then why should abortion not be allowed?
Well, okay, I'm not going to repeat myself because there are people that have their hands up. Karen?
Back to that first sentence, the logically of course one.
Yes.
I think they're saying that we can weigh in on this without determining where life begins.
Yeah.
I don't think that they're claiming to say when life begins. They're saying without making that determination, we're going to take a stand on it. We're going to say whether it can be legal or not. And then the less rigid claim, I think they would say, and they would call rigid saying life begins at conception or that life begins at birth. Like that, both of those are definitive statements, and that's what's rigid, not.
Karen, I have a problem with that because the problem I have is it's sort of like the argument, well, he says what the Palestinians, what's being done to the Palestinians is wrong. He says what's being done with the Israelis is wrong, so the truth must be in the middle. This notion that the truth somehow has to always be between
I don't think they're saying that,
extremes.
though. They're saying we can't determine what the truth is, but we're going to weigh in on it anyway.
You see, I have okay, Karen, I'm willing to slug it out. You know, I'm willing to argue it out. I think that's a logical impossibility.
Which?
If you believe that life begins at conception, it has to be the case that the state has an interest.
But they're letting you determine that for yourself. They're not making that determination.
Yeah,
and they're owning it. They say through that, they're like, we can't, people fought this for millennia.
If the life, if the life begins at conception, you can't determine it. It's a life. And then it's over. The state has an interest because if you kill it,
But
it's
they're
murder.
not even making that argument. That's your argument. That's not their argument.
Yeah, but they're making
They're saying we can't determine that. Leave that to someone else.
Yeah, but they're saying more than that. They're saying it can't be determined, yes.
They're saying people have tried to determine it and have not settled on it. And
Yes,
they weren't going to solve it like that.
Carrington. They're going to say in a moment that, in our opinion, the state has the right to intervene at the beginning of the third trimester because the life is viable outside the fetus. Okay?
But they present that as arbitrary. They don't say, like, this is definitively when life begins. They're saying, this is where we're going to put it, just here.
Yeah, but there are two problems with that. Problem number one, if life truly begins at conception, then your position is not, referring to the court's position, it's not less rigid, it's justifying murder. It's very easy to say we're less rigid.
Strict definition, I think, is what they mean by rigid.
What?
The strict definition of life beginning at conception.
I don't think that's necessarily rigid. You're using the argument that because it's one of the extremes, it has to be wrong. I think an extreme can be right. Just because
but they're not saying it's wrong. They're saying it's less rigid
our
or it's
position
rigid.
is less rigid.
They're not saying it's more right. They're saying it's less rigid. It's less definitive.
Rigid has a connotation. It's called being inflexible, being uncompromising.
Being more certain.
What?
Being more certain.
Of course, I'm saying we are being scientific and rational about it.
You're
being dogmatic about it.
I don't think
That's what I think.
But they don't say that about people.
Let's take a reverse situation.
If
Some pro-choice person says, I think life begins at 2 years old. And another, and pro-life says, it begins at 1 year old. So then the court decides, we're going to say life begins at 1.5, so as to be less rigid. Would you accept that as being less
I just don't
rigid?
think that's what they're doing. I think, look, we've got to pick somewhere. We're going to weigh in on this. What would be fair? And they don't pretend they're not being arbitrary to some extent.
I would go for that. I would go for that, except for two things. Number one, I would want the court to say we're being as arbitrary as anybody else. It has nothing to do
They
with
kind
being
of do
rigid.
say that.
It has nothing to do with being rigid or flexible. We are as arbitrary as everybody else in choosing the cutoff point. It's
They
a
say
purely
this is as good
arbitrary-
a place as any. I mean, they're not saying like this is the place. In my recollection of the reading.
Right, but Carrington, then 1.5 is as good a place as any.
It's different because you're talking about whether you can abort a fetus. I mean, that's a different conversation.
I don't think so. But
It's not a fetus once it's out of the womb.
But you see, you're being rigid now because you're assuming the fetus is not a child. I think that's rigid.
Oh, I thought we were talking about a life inside a woman's womb. And whether or not we would
Yes,
terminate
we
it.
are.
Once it's outside the womb, is it still a fetus? Yeah. I don't think so. But
Okay. Ellen?
Yes. First of all, the fetus is not viable or was not viable at 3 months. That's when they intervened to protect the mother. They said
Yes.
it's in the 3rd trimester, or 6 months, that it becomes viable and it becomes arguably homicide. No, I completely agree with Karen.
What is viable mean?
Can live outside the womb.
without necessarily doing like
Okay,
A 6-month fetus could be put in some kind of protected
without, like,
environment
Okay.
outside the
Now
womb
they
and-
can do it
If I
early,
can-
not 3 months.
I'm just getting a definition.
If I
Thank you.
can, you mix a metaphor. Let's not beat the fetus to death. Let's move on.
Oh.
Okay. Move up, move up. So the first question we've already looked at, in assessing the state's interest, recognition may be given to the less rigid claim that as long as the at least potential life is involved, the statement is okay. Well, okay, so we're going to just read it to yourselves, or read that loud. While pretending that it is being neutral and objective, doesn't this assertion by the court make critical or undemonstrated value judgments about where life begins? Why is it less rigid to believe that life doesn't begin at conception? I don't think that's less rigid. It's as legitimate and as flexible or inflexible a starting point as any other. If life truly begins at conception, then what the court calls a less rigid view is actually a more immoral one. If you truly believe life begins at conception, what the court calls a less rigid view is in fact a more immoral one than the pro-life position. Likewise, how does the court know that potential life doesn't begin at conception? It's using a definition of potential life, viable outside the womb. But that's also an ideological claim.
Well, by that logic, you can ban contraception, which they did throughout it.
There is the question, yes, of...
Because every sperm is a potential life.
I know, that's...
And may I write, they're spilling their seed. Please, thank you. It's a sin.
No, it's not a
It's Jewish
sin.
law. Please.
It's not a sin, it's murder, under mass scale.
Mass murder.
No, it's murder. Okay, let's go on. Who would like to read? You read.
The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as et cetera,
Don't read all the numbers, it's not important.
the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. This right of privacy, whether it be founded in the 14th Amendment's conception of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined, the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
Okay, so right now, the court is going to essentially say that that 14th Amendment, which refers to a right to liberty, that the right to liberty includes a right to privacy, and the right to privacy encompasses and includes the right to abortion. So as you can see, there are many links in their argument that cannot be found literally in the Constitution, but they're making all sorts of deductions which they claim are either latent or implicit in the Constitution. So the Constitution, the 14th Amendment, speaks to a right to liberty. The right to liberty, it then says, includes a right to privacy, and the right to privacy, the court says, also includes the right to abortion. It will not have passed over the heads of anyone in this room that those are many tenuous links, which even as you look at the Constitution under a microscope, are very hard to discern. And it points to, again, what seems like a court usurping its authority and legislating for the whole society. I personally find it very difficult to see in that Constitution, in particular that 14th Amendment, even by the most numerous deductions, a right to abortion. Correct. I think that's just politics disguised as law. So let's go on. Let's at least finish the paragraph. Go ahead.
The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable, even in early pregnancy, may be involved. Maternity or additional offspring might force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress or concern associated with an unwanted child. And there is the problem of bringing a child into a family already unable, psychologically and otherwise, to care for them. In other cases, as in this one, the additional difficulties and continued stigma of unwed motherhood may be involved.
The Roe, the person who was Jane Roe, she was not married when she asked for the abortion. The person who brought the case before the court.
All these are factors the woman and her reasonable, responsible physician necessary for considering consultation. On the basis of elements such as these, appellant and some amici argue that...
Amici or amici, that just means when you go to court, particularly the Supreme Court, all sorts of other organizations submit what are called friend of the court briefs. So let's say in this case, Planned Parenthood would submit a brief, or on the other side, some right to life organization would submit a brief. Go ahead.
And some amici argue that the woman's right is absolute and that she is entitled to terminating pregnancy at whatever time, in whatever way, for whatever reason she alone chooses.
Okay. Now, let's just quickly look at the questions. If life does begin at conception, do these admitted harms suffered by a pregnant woman warrant aborting the life? They list many harms that a woman must endure, that a woman must suffer. But if you believe that life begins at conception, do these harms outweigh the child's life? Again, have they made a convincing argument? Does a woman have to believe that life doesn't begin, well, this is the question I put to Carrington earlier, does a woman have to believe that life doesn't begin at conception in order to justify an abortion in the name of these admittedly onerous harms? Even if you acknowledge these are serious harms, they are onerous burdens for a woman to have to bear. Is it morally possible for a woman to justify aborting a child because of these burdens?
Absolutely not. It's like a week after the child is born, and she realizes she really can't afford to feed this child. And she may have to kill this child in order to save the other two because she's barely able to feed them. We would call that murder, right? I mean, I don't think that. I'm kind of saying, well, but it's murder, right? It begins life, begins understanding.
I think there's in relation to this question and the previous one, I think we're sort of assuming that because if life begins at a conception, it automatically means that abortion is wrong. Well, I'll say the argument is, to me, I think the less rigid argument is the most morally bankrupt argument in abortion. I say this as someone who's very pro-choice, but I can only accept arguments that whether are pro-life to the point of no exceptions. Because if you really believe it's wrong to kill a life, then I understand that. It's those, or the pro-choice argument, which is it's always fine to have an abortion. I can't accept the middle ground because I find that morally bankrupt.
I think that's an argument there.
Yeah.
It's either one or the other. It's what they call the less rigid position is actually the most hypocritical position.
I agree. Yeah,
because if you start making exceptions, the next question reads, would even rape or incest justify an abortion if it were shown or believed that life began at conception, that the embryo was a full-fledged life? Well, the answer is obviously not. If you believe that that's a baby, then how could you make an exception for rape?
I think, and I just want to say one more thing. I think a better question.
I think the point, can you remind me of your name?
James.
I think James makes the interesting point. The most hypocritical position is actually the court's position. What they call the less rigid position, in fact, it's the most hypocritical. The really consistent positions are the two extremes. You believe it's life and you say no exceptions, or you believe it's not life and you say, well, a woman has the right to do as she pleases.
And as a pro-choice person, I can respect someone who's pro-life and says no exceptions, but I can't respect a person who's pro-life but says, but with the exception of rape or incest or anything like that.
Right. Yeah. Or having an affair and being a congressman.
But maybe when it was when they were trying to put together a majority for this vote, they had to compromise it, and that's how they came to the middle position. You know, people may hold extreme positions, but if you want to come to a majority in a court, in a 5-4 decision or whatever, you are going to have to compromise the absolutes to find a middle position that can carry.
I could see that, but I think, as I've said, to the point of tedium and boredom, the problem is the court is using loaded language. It's saying that our position is less rigid. No, your position is, the court's position is as arbitrary as any other, arguably more hypocritical at a moral level, and the court should just have said that.
Has there, well, I'd like to ask another, has there ever been a court decision where the court comes out and says, we are immoral in our decision, but look, they try to be convincing.
The court would say, we recognize this is an insoluble question at a scientific level, at a medical level, at a moral level, at a philosophical level. We recognize it's insoluble. We also recognize we might be wrong, that maybe future medical insight is going to show us to be wrong. We recognize that, but for the sake of trying to solve this question, this is what we come to. And you know what I would say to them? I would say to them, you shouldn't be ruling. We still live in a democracy. If there's no definitive answer one way or another, it should be people who have the right to vote and decide it. I don't see why the court is doing this. I think what they're doing is completely arbitrary, and I think it's a usurpation of power. Why should we care? 9 people, or less than 9, because it was 72, I think. 7 people came to this arbitrary conclusion and then imposed it in the whole of our society. I don't agree with that. if you could have shown me a compelling legal argument, it's right there in the Constitution. Look there in the Constitution, it says abortion is legal. Okay, you win. It's in the Constitution. Well, we went in the Constitution from a right to liberty to a right to privacy to a right to abortion. That's a lot of leaps. That's a lot of leaps.
But doesn't the Constitution say all those rights that are not here enumerated?
Yes, that's the Ninth Amendment. Yeah, but then that's the Ninth Amendment. But then they're deciding this is one of the unenumerated rights. I would say this right is as clear in the Constitution as the right to barbecue in the summer in your backyard. I'm serious, I don't see any right there. I just see a lot of leaps which they pretend follow logically or implicitly from the Constitution. I don't see it. Before you chime in, I want to get to what seems to me the toughest argument. The toughest argument. I once had a conversation with Professor Chomsky on the question of abortion, because he never really much publicly commented on it. I was curious where he stood. And I noticed, unusually for him, there was a certain amount of reticence and uncertainty. And he said as follows. He said, I hope the paraphrase is correct, he says if you look at the long sweep of human history, you see that the notion of what is a life, it gradually expands. You know, there was a time where slaves were not considered human. And then there were all sorts of laws which allowed for, even if you read Plato's Republic, for killing defects. You know, human beings who were born with what we call nowadays Down syndrome, or born with all sorts of physical disabilities, we didn't really count them as life. And he says, if you look at that long trajectory, he said, the notion of what constitutes life gradually expands. And it follows, as you can guess, that by that argument, where life begins gradually goes further and further back. And so, what he, to conception. Because there was a period when we didn't even consider babies that were born with physical disabilities to be life. And then we conceded they were life. And so he says, the trajectory is to expand the notion of life. And you can understand from that argument where he was heading, that he was quietly saying that probably in 500 years from now, they're going to say the pro-abortion position was wrong. Nonetheless, I don't know, roundly will survive, but if we did. And so that brings me to my last point. My last point says, we don't know where life begins. Everybody can agree with that, yes?
Yeah.
We also agree, when we talk about life, we're talking about the most sacred of principles. It's life. So I say, when it comes to human life, shouldn't we err on the side of caution? If it can't be proven one way or the other, the cautious response, because we're dealing with life, should be to assume the embryo is life. Yes, you can prove it, but if it's life, then you have to err on the side of maximum caution. It's the same thing with the climate debate. There are, we have to acknowledge, some very good scientists who deny climate change. There's a very good scientist at MIT. He denies climate change. So then we say the following. Let's say, for argument's sake, that it's only a 25% possibility, climate change. It's only 25% possibility. Not the 95, let's call it 25. I say, since we're talking about the survival of the planet, the species, 25% is quite enough to do something about it. You know, it's serious business. We don't need 100%. 25% is enough. Let's get our act together. So I say the same thing here. Even if it's, let's take the extreme. Even if it's a 5% chance it's life. Because we're talking about life, we should still criminalize abortion. Yes?
One point, I mean, it may be really off track, but, and it's sort of like precedent, but it's a biological fact that early in the first trimester, I don't know what the percentage is, but a fairly high percentage of miscarriages. And so socially, people don't treat those miscarriages as a death, as a grieving. I mean, I think it can be very devastating for the parents. If you said something, people keep quiet, and maybe if someone's younger, and then they can immediately get pregnant, but if someone's really trying to get pregnant. But so there is this somewhat natural process of something, you know, sometimes maybe because there are real problems with the fetus. But so like, for people who are very pro-life, it's not like they say, make a bigger deal of that, like a funeral.
No, I think that's a strong argument. Because one of the arguments that has been made is there's never been a case in any legislation of abortion being charged as murder. So, you know, there's been misdemeanors, there's been felonies, but never murder. And so if you truly believe that the fetus is a child, then you should be charging the mother or the doctor with murder. But there's never been legislation that has called for that. Yes, it's true, you know, abortion, pro-choice activists will say abortion is murder, but as a legislative fact, it's never been legislated as murder. So consistently, your point being miscarriages have never been seen as deaths. It's been seen as something short of death. In the same way, abortion, at least legally, has never been enacted as legally enacted as murder. I want to just
like
see
really short of death. I mean, it's more like treated like a cold, and a woman should go on with it.
No, but you will agree that many women treat a miscarriage as something really.
Yes, I agree with that.
I know
Just trying to
instance.
decide.
Okay, we're going to take 3 comments and then we're going to move on because I'm going to finish Roe v. Wade. I'm trying to make a joke, I can't figure out one. Yeah. Carrington, you, and go. Go ahead.
I know someone who drunkenly got in an accident with someone who made the woman miscarry, and they charged her for involuntary manslaughter.
Sure.
Yes.
Yeah,
So the woman I know was alcoholic, or was drunk, killed the baby. She hit the car. The woman in the car was pregnant, lost the child, and the woman I know was charged with involuntary manslaughter. So that is a case of murder of a miscarriage.
Yeah, I'm just curious, did she win the case?
No, she went to jail for 2 years in California.
How far advanced?
I could probably find out, but
You know,
4 or 5 months. I don't think it was like almost there. I think it's sort of in the middle.
I would still say, well, I know the case because actually I was reading about it. But involuntary manslaughter is still short of murder.
I think that's it. Wait, that was in the news?
It was a famous case.
Oh, it was? I just saw it.
Okay, yes?
I'm actually surprised that it's taking us so long to figure out when life begins. We do know, and this came as news to me, maybe we've known it for years, but I didn't. There's a heartbeat already when the woman is 6 weeks pregnant. And maybe a week later or less, the fetus can already feel the pain. So, I mean, according to the way I see it, once a fetus can feel pain, I'm not saying it's a fully formed human, of course, but it should help us make the decision when does life begin.
I think that's a very tough one because we all know that animals feel pain and most people assume are not vegetarian. So the standard can't be feeling pain.
Well, are you comparing killing animals to...
If you're using the standard of pain, of course I'm comparing. I happen to be a vegetarian and I do believe the standard should be sentient life. Anything that has feeling should not be...
So you're putting the value of the life of an animal, same value or something?
Yes, I do believe that proverbial 500 years if we're around, that future humanity will view our carnivorous behavior the way we view cannibals.
I believe chicken is the same as that.
I see no difference between cannibalism. Listen, if there were a difference, then none of you would be appalled. If Mary had a little lamb, the lamb was white as snow, and everywhere that Mary went, the lamb wanted to go, and what the last line was, Mary ate the lamb. That wouldn't be a very fitting end, right? Because Mary loved the lamb loved Mary, the lamb was a sentient being. So I don't see anything in principle between that and cannibalism, but I don't think that works here, because if you use the standard of feeling, then that would include every animal, and most people know.
Like a heartbeat.
Hey, the lamb had a heartbeat.
Anthropomorphic. Not every animal has a heart.
You, go ahead.
Yeah.
I would go with your previous argument. If it can't be proven one way or the other, what right does the court have to decide it? Why shouldn't it just be kicked to the legislature? It doesn't have a place to decide it. That's not written in the Constitution.
The court says they have a right to decide it.
It's Talmudic, but it's not constitutional.
Because it bears on the question of privacy. That's how they see it. It's the right of privacy. But that begs the question. The problem is, it's only a right of privacy if you assume the baby, the fetus is not a child. Otherwise, it's not private. It's just a circular argument. It only becomes private because you assume the fetus is not a child. If you assume it's a child, then it's no longer a privacy issue.
Wasn't slavery defended on those grounds?
Yes, on the grounds it was property. It was private property.
By your definition, taking antibiotics would be an act of animal murder.
Because?
Because we have organisms that live within us that we are killing.
That would kill us if we didn't take care of them.
By the way, that doesn't scare me because I don't take antibiotics. I've only taken aspirins. Okay, that's just... Okay, I haven't heard from Barbara and James. Go ahead. Barbara. And, excuse me.
Very quickly, this is just a question about what is life.
This is a personal thing. Some friends of mine became pregnant. They were an older couple. They were delighted with pregnancy. However, when she had her sonogram done, she just was birth defective. No kidneys, a malfunctioning heart, and they had to, make the decision to divorce. Of course they did, because bringing too many congenital defects. Now, is that something right? I mean, where does one stand on that?
And those are tough issues. Because, some things are not susceptible to legal adjudication. Most women, I think, but obviously we're the experts here, if they have amniocentesis, and it's found that the child's going to have Down syndrome, they will want to abort. On the other hand, most women, if the child is born, will love that kid to death. That's
relatively mild.
That's not as bad as.
Yeah.
That's the nature of being human. It doesn't easily fit into compartments. I have a friend, he's in Switzerland. His fourth child was born with all sorts of defects. He loves that child like there's no tomorrow. But I'm also positive if he had known that before, he would have said it more.
So perhaps life would be for the child. It depends how bad.
I don't know. Ask Stephen Hawkins.
He wasn't born.
No, he was not.
Most kids with defects like that are not Stephen. And he wasn't born. He might not have gotten to where he was.
I honestly don't have any answers to these questions. I don't think it's useful. It's only one reason why the court shouldn't be deciding that.
Yeah.
There's no answer in the Constitution to these questions. There's no legal answer to these questions. You can move on in the court. Mike. Okay, what I'm going to do is, we have G. I want to finish this. G, H, I. Okay, let's just move ahead so we can officially finish it and we won't feel as if you have been cheated by not reaching the finishing line. Jean, who would like to read it? You have not talked, and in the Finkelstein class, everybody has to participate. Everybody has the constitutional, inalienable right to make a fool of themselves.
With this, we do not agree. Appellant's arguments that Texas either has no valid interest at all in regulating the abortion decision, or no interest strong enough to support any limitation upon a woman's sole determination, are unpersuasive.
So they say that either extreme is unpersuasive, the pro-choice and the pro-life.
The court's decisions recognizing the right of privacy also acknowledge that some state regulation in areas protected by that right is appropriate. As noted above, a state may properly assert important interests in safeguarding health, in maintaining medical standards, and in protecting potential life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain regulation of the factors that govern the abortion decision.
Okay, so they're establishing at some point the medical issues become, the medical issues become sufficiently important that the state can intervene. Go ahead.
The privacy right involved, therefore, cannot be said to be absolute. In fact, it is not clear to us that the claim asserted by some amici that one has an unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court's decisions. We therefore conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests in regulation.
Okay,
I know that he should do all the reading.
No, no.
Just not have to like the
Yes,
accent.
it's wonderful.
I didn't
Female flattery will get you nowhere. Okay, the questions I posed have already been answered or discussed. There are no answers. So go on to H.
H. The pregnant woman cannot be isolated in privacy. She carries an embryo and later a fetus if one accepts the medical definitions of the developing young in the human uterus. The situation, therefore, is inherently different from marital intimacy or bedroom possession of obscene material or marriage or procreation or education with which Eisenstadt and Griswold, Stanley Loving Skinner, and Pearson Meyer were respectively concerned.
All they're saying here, don't get alarmed. All they're saying here is in these previous cases, we also dealt with the issue of privacy. For example, in the case Stanley, they dealt with the case called Stanley. They dealt with the issue of privacy having to do with consuming obscene material in your home. The case of Loving dealt with the question of whether mixed marriages were legal because there were laws throughout the South which prohibited marriages between blacks and whites. They were called the anti-miscegenation laws. So all the cases they're looking at dealt with issues of privacy. And they're saying this issue of privacy is not exactly the same as the other issues because this issue of privacy at some point involves another life. Namely, they're going to claim the third trimester. Go ahead.
As we have intimated above, it is reasonable and appropriate for a state to decide that at some point in time another interest, that of health of the mother or that of potential human life, becomes significantly involved.
Okay. Obviously, what I'm going to say is it's again the loaded language. They're claiming that the point that they choose is the reasonable and appropriate one. But they've never given any proof that it's reasonable or appropriate. They've just stated it, just like as they call the other positions less rigid. Here they're claiming their position is more reasonable and more appropriate. I don't think they've ever demonstrated that. All they've demonstrated is that their position is as arbitrary as the others. Now, I don't know if Carrington agrees or not. I'm looking at her face. I'm inclined to not see an argument here. This is just claiming, using loaded language, that yours is the more reasonable and appropriate position, but never having proved it. Go ahead.
The woman's privacy is no longer sole, and any right of privacy she possesses must be measured accordingly. Texas urges that life begins at conception and is present throughout pregnancy, and that therefore the state has an entire interest in protecting that life from and after conception. We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary at this point in the development of man's knowledge is not in the position to speculate as to the answer.
To which I would say, I think they are deciding. Because if they believed it began at conception, they would reach entirely different conclusions. I think this is completely disingenuous. They are deciding. They're pretending not to.
agnostic.
What?
They're agnostic.
I don't think they're agnostic. Because if they said, if you believe life begins at conception, then what you're doing is murder. They're saying, we don't believe it begins at conception. They're pretending that they're not taking a position, but they're taking a position. They're taking the position that the state can legitimately intervene in the third trimester. So for them, life begins in the third trimester.
Sorry. No, this is where I have a problem.
I would like you to continue apologizing to them and see how long you can last.
I have this problem, this assumption that, so if you believe life begins at conception, that means abortion is murder.
Yeah.
I feel like that's the wrong answer. I feel like that's the wrong question. I feel like we're basing this argument whether or not does life begin at conception or not? And based on those conclusions, we decide whether or not abortion is wrong. I think a better question would be, what makes killing wrong? And I think that opens a new door where I think that comes to the conclusion where abortion is permissible.
James,
What?
that sounds like a psychopath's question.
Could I make a psychopath question? Because I think the better question is, when does personhood start? There's a difference between life and personhood.
And what about the
I would
mother
say,
dying of peritonitis in the hospital?
I don't.
The young 18-year-old girl.
Yeah. Because
whatever side you want to defend, I would not use that line of attack before.
No, I think maybe that's why. That's why it hasn't been brought up, because anyone who brings it up sounds like a psychopath. Until you let the psychopath make its case, then you realize, oh wait, that psychopath had a reasonable argument, which I think is
psychopathic. Let's
okay.
this.
Right.
Allow me, because I'm watching the clock. Go ahead.
Okay.
It should be sufficient to note.
It should be sufficient to note briefly the wide divergence of thinking on this most sensitive and difficult question.
Namely, when life begins.
There has always been strong support for the view that life does not begin until live birth. This was the belief of the Stoics. It appears to be the predominant, though not the unanimous, attitude of the Jewish faith. It may be taken to represent also the position of a large segment of the Protestant community, insofar as that can be ascertained. Organized groups that have taken a formal position on the abortion issue have generally regarded abortion as a matter for the conscience of the individual and her family. As we have noted, the common law found greater significance in quickening. Physician and their scientific colleagues have regarded that event with less interest and have tended to focus either upon conception, upon live birth, or upon the interim point at which the fetus becomes viable, that is potentially able to live outside the woman's womb, albeit with artificial aid. Viability is usually placed at about 7 months, 28 weeks, but may occur earlier, even 24 weeks. But they said earlier on that they're...
Okay, what I'm ready to do is, let's just finish this next week, because I just want to see what they conclude, and then we'll move on to the next one. So be prepared for the next case, but I feel that we should read it to the end and just see what they conclude. As always, very good class.
Thank you.
Thank you.
Thank you very much.
Particularly the teacher.